Good morning, Council. My name is Judge Anthony Powell, and I'll be our presiding judge this morning for the Wednesday morning docket on November 17th, 2021 docket of the Kansas Court of Appeals. We have two cases on our docket today. I'm very pleased to be joined this morning on our panel with Judge Gordon Atchison, who is one of our senior judges and one of the most senior members of our court. And then Judge Richard Walker, who's a senior judge, retired district judge from Harvey County, is also with us on this panel. I'm very pleased to have them with us to work these cases. The first case on our docket this morning has a number of parties, and we did receive council's email on how appellees want to divide up their time, so that's very helpful to us. But I will call the case, and I'm going to ask the parties to give their appearances. The case is the Payne Consortium Center of Greater Kansas City versus Parkway Plaza Retail Office Owners Association and North American Savings Bank and FirstService Residential Missouri, Inc. And could the court have the appearances starting with the appellant, please?
Tom Franklin for North American Savings Bank, FSB. Appellant.
Thank you.
Michael Halloran for Parkway Plaza Retail Office Owners Association, Incorporated.
Thank you.
Michelle Burns for Payne Consortium of Greater Kansas City and Palo Verde Group LP as appellee and cross appellant.
Thank you.
Marcia Wood for FirstService Residential Missouri, cross appellee. Very
good. As I understand it, according to the email from Ms. Burns, the appellees intend to divide up their 20 minutes, and this is a 20-minute case per side. Ms. Burns, you're going to proceed first. You plan to go 10 minutes, and
That's
then Ms. Wood, you are going to go second and use 5 minutes, and then Mr. Halloran, you'll be third, and you plan to use up 5 minutes. Have I got that correct?
Yes.
That's correct, Your Honor.
Yes, Your Honor.
Very good. Mr. Franklin, your client's the appellant in this case. You have 20 minutes. Would you like to reserve some time for rebuttal?
Yes, Your Honor, 10 minutes.
10 minutes for rebuttal. Very good. All right, Mr. Franklin, you may proceed. I'm going to be the timekeeper. Go ahead.
May it please the court. I'm going to move first to the first issue in the appellant's brief, which is the argument A. That's the issue regarding the claim by Payne Consortium here for breach of an owner to association contract. And I'm going to start on that issue with the issue of the failure of the plaintiff to establish its standing in this case. As pointed out in the, and I'm going to refer to my client as NASB. In the NASB brief, the law after Calavig, and apparently before that too, was that if you are claiming a right to enforce a contract, you have to be in a position to prove at trial that you had a right to enforce the particular contractual provision you are seeking to enforce at the time you filed the pleading asserting that right to enforce. The problem here is that the provision that the plaintiff was seeking to enforce were the provisions of the declaration that were in section 20 and 22 of the declaration, which were the provisions for the payment of monthly assessments and what would happen when there was a delinquency. Here, when originally this case was filed, and at the time Payne Consortium pleading was presenting a different contract than what I am discussing right now. It was presenting a breach of contract claim in which it asserted that NASB had breached a contract to sell a fourth lot that included a provision that would assign the rights to be the developer. Actually, they referred to it as the rights to handle development to Payne Consortium. And throughout the first approximately 14 months of this case, there was no claim asserted that NASB had not been paying its lot dues and that there was some contract that Payne Consortium could enforce for the payment of lot dues by NASB. In April of 2015, when Payne Consortium filed its first amended petition and first asserted a right to enforce sections 20 and 22 of the declaration, NASB had brought its dues current. And under the reasoning in Calavig, NASB argues that when those dues were paid in full, there was no further right to seek enforcement of sections 20 and 22 of the declaration. That is the first element of, or first, I guess, subcategory of the arguments that Payne Consortium or that NASB made with respect to standing. And I don't believe that the facts as proven at trial establish anything different than that. In other words, there was evidence presented, it was not rebutted, that NASB by April of 2015 had brought its dues current. And of course, the undisputed evidence was that for the longest time, NASB had not brought its dues current because it was not being billed proper amounts for dues. And in that regard, NASB was much different than the other 14 to 16 owners in Parkway Plaza because it was in the process of selling tens of thousands of square feet of lots, and per the declaration, when the ownership of a lot changed, the duty to pay dues changed. In other words, the duty to pay dues was always per the language in sections 20 and 22 attached to the owner of the lot, and the owner of the lot is defined in the definitional sections in section 1 of the declaration as the record title owner. So the core problem here that has led to much litigation is that during the period of 2012 to 2013, when the sale of lots occurred and a new owner of lots arrived and took title, FirstService was not keeping up with the change in title. And for that reason was still making accounting entries during that period that showed NASB, that was no longer the title holder, as having responsibility for dues that, as a matter of the provisions of the declaration, it did not have responsibility. So when Payne Consortium undertook in April of 2015 to file its first amended petition and start asserting a claim that it had a right to enforce sections 20 and 22 of the declaration for failure to pay dues, it put Payne Consortium as the plaintiff in the position of having the burden of proof to demonstrate the provisions of this contract, to enforce dues, and to prove that NASB was a party against whom the association had enforcement rights. And quite simply, under Calavig, when dues were paid up, there was no right to enforce by the association against NASB for failure to pay dues. Moreover, as a plaintiff here, claiming a right as a third-party beneficiary of the contract of the declaration between owners and the association, the plaintiff had the burden of proof to establish exactly how much was owed at each time that money was owed. And the plaintiff had the burden to prove that there had been all of the other requisite elements under sections 20 and 22 for enforcement. And as sections 20 and 22 provide, and here I'm referencing the provision in section 20 that refers to notice to be given to each owner of dues, or as they're referred to in the declaration, assessments. There was never any proof by Payne Consortium that a notice was given that was proper for each of the dues that might have been owed in 2012 and 2013 and 2014.
May I interrupt you for a moment? You have used 10 minutes of your time. Do you wish to stop and hold the rest of your time for rebuttal, or do you want to continue?
Let me stop here and reserve the rest of the time for rebuttal. NASB will largely, with respect to the issues against FirstService and against the association, stand on its briefs.
Very good. Thank you. All right, we'll hear from Ms. Burns. Turn your mic on there, counsel. I always forget that too.
I was listening. Thank you, Your Honor. First of all, this appeal is not an opportunity to relitigate the facts, but to determine whether or not there was substantial competent evidence to support the trial court's decision with regard to NASB's appeal. It is our position that there was substantial competent evidence to support the trial court's decision. This is a contract, and whether a contract exists, the court uses the same rules it applies to interpret contracts as it does to interpret restrictive covenants. The terms of the contract are clear, and the intent of the parties is to be determined from the language of the contract without applying rules of construction. it seems as though NASB is arguing that with regard to both of its issues as to Payne Consortium and Palo Verde, that our claims for damages and to enforce the declarations against NASB was simply because of their failure to pay dues. But that's not it. I mean, and the trial court found it was their failure to pay dues and the impact of their failure to pay dues from the time they took ownership in 2010 until the appointment of the receiver in 2015, where they got credits and adjustments and said they brought them current. But the impact that that had on the overall development, the damages sustained to my client's property as a result of that, in addition, as the developer and as the owner, their failure to comply with the articles, the bylaws, the declarations, their failure to make sure the property management company was doing its job. As the trial court found that NASB had a multitude of bad acts and breaches of the declarations. And Mr. Franklin is isolating certain parts of the declarations to try to appeal the trial court's decision, but the interpretation of the declaration should not be based on isolating one particular clause or sentence, but considering the contract as a whole. And
from this, looking at standing on this, I mean, your claim is that the failure of the bank to timely pay dues over a period of years had a ripple effect on the value of the lots that your client owned, that you have standing to seek damages for that diminution in value. I mean, that's part of the constellation of claims you're making, and that's what you're saying you have standing to assert, right?
yes, we have standing to assert that.
Now, I mean, there were some other issues about whether you had proven those damages, but the proof is different from an argument of lack of standing.
Correct.
Okay. I just wanted to make sure I understood what you're claiming
Yes.
at this point. So, okay.
We are claiming that we had standing under the declarations to sue NASB as the developer and as an owner, because the declarations allow any owner to sue to enforce the declaration or any other rules or guidelines. And for
Right.
any-
But the injury stemmed from the bank's failure to pay the dues timely over an extended period. And that's the damage. So the fact that they may have brought them current years later doesn't undo that harm and doesn't correct for the harm that you were asserting.
That's correct.
All right.
And that's not the only breach that we were suing for. That harm and everything.
I understand, but that's a piece of it. And you're alleging that you had standing to sue based on that, regardless of whether they eventually got current or not.
That's correct, because that
Okay.
caused damage to our property. And they claim that we don't have standing because of a provision in the declarations saying that they can't be held personally liable for failure to enforce. That's not what we sued on. We sued based on all of their breaches. The language of the declaration is clear that we have the right to sue to enforce the declarations and for any damages. Our suit is not about their failure to enforce any provision of the declarations, but for its own breaches. The association was never in the hands of the owners until after the receiver was appointed in April of 2015. The structure of the declaration has the developer as the approving party. And the declaration created a contract that ran with the land between the owners, and NASB was an owner, and the developer and owners, and NASB was the developer. And the trial court found and properly concluded that NASB failed in its exercise of its duties as the developer and as the owner for failure to pay dues. And it did not exercise reasonable control over the property management company. And that FirstService was even, their lack of performance was largely based on NASB's other substantial failure to pay dues. And their hands were tied because they didn't have the funds to properly manage the company, the development. NASB had no authority to defer its dues. NASB had a duty to act in good faith and fair dealing because all of its actions were self-serving. They didn't undertake action. They stated they were not in the business of owning real estate. They wanted to sell their properties. Their own admissions were that they were going to have trouble selling their properties because of the condition of the development, and that caused damage to my clients in the value of their property. Now I'll go on to argue our position as cross appellant. Attorney's fees, the declaration provides that each owner shall have the right to sue in any action at law for damages. And if an owner shall be successful in obtaining a judgment, the enforcing owner shall be entitled to receive from the breaching owner or developer attorney's fees and expenses. So
Would you agree that that provision would entail reasonable attorney's fees?
yes,
I mean, even though the word reasonable doesn't appear there, it has to be construed to mean reasonable fees under the circumstances.
yes, I do.
Ms. Burns, is it your view that the contract is mandatory, that if you're the prevailing party, you're entitled to fees, and it's not a discretionary
Yes, you're right.
act for the district judge? Because it seems like the judge here sort of weighed the equities of whether attorney fees were appropriate and didn't feel, based on the equities, that you were entitled to attorney fees. I take it that your view is that's not what the contract provides, that once you've prevailed in the lawsuit, you're entitled to reasonable attorney fees. Thank you.
Correct. That's correct, because it says shall be entitled to. And then in terms of the damages with regard to the other lots, obviously the trial court found that our experts' opinion and methodology to damages as to one lot was, appropriate. And so no reasonable person would find that his same methodologies and opinions as to the loss on our other lots was not also substantial competent evidence as to those damages.
Yeah, as to the particular lot that the judge awarded damages on, your clients actually sold that. So there was a market value based on the sale as compared to what your expert said its fair market value would have been had the entire development been properly maintained. Is that correct?
Yes.
Okay, and that differs from the other lots, which were still being held and had not been sold, right? It's a factual matter.
Well, I don't think so. I think the same methodology was used on all of them.
Well, I understand it's the same methodology, but the one is a comparison to an actual sale. There is no actual sale of the other lots. I mean, they're still being held, correct? I mean, factually, that's correct. And you're saying that really shouldn't make any difference.
Yeah, that's correct.
Okay.
Ms. Burns, I see you used up your 10 minutes. If you want to wrap up.
That's all I have. Everything
Very
else is in the briefs.
Okay, thank you. Ms. Wood, we'll hear from you.
May it please the court, FirstService asks this court to affirm the district court's decision in its entirety. And I would like to address specifically the district court's denial of the bank's claim for indemnity against FirstService. That indemnity claim is based on a cross-indemnity provision in the property management agreement, which was an agreement between FirstService and the association. There is no indemnity agreement between FirstService and the bank. What NASB claims is that as a lot owner in Parkway Plaza, it is a third-party beneficiary who is entitled to the benefit of the indemnity in the project management agreement. The district court correctly declined to expand FirstService's indemnity obligation under the property management agreement and ruled that the contractual indemnity did not cover a third-party beneficiary for losses caused by its own breaches of another contract. That ruling can be divided into two parts, and either one of those is sufficient or both to affirm the district court. One, that the indemnity does not reach third parties. And two, that the indemnity does not cover claims for losses that the indemnity caused by breaching a different contract. As the district court stated, FirstService's indemnity agreement was with the association, not with the bank. And that's at volume 1, page 422 of the record. The project management agreement says nothing about indemnifying third parties such as lot owners. And I want to point out that the district court did not hold otherwise. So that will come up again later. The district court, the project management agreement certainly does not say that FirstService agrees to indemnify a lot owner that is sued for breaches of the declaration or the developer sued for breaches of the declaration. And this interpretation was correct as a matter of law. In Kansas, indemnity clauses in contracts are not favored, so they are to be strictly construed. In addition, anytime someone brings a claim as a third-party beneficiary, the intent to benefit third parties must be clearly expressed in the contract. Putting those two together then, the intent to indemnify third parties needs to be expressly stated in the indemnity provision, or there is no indemnity of third parties. The bank has never cited any law to the contrary, and there simply is no clear expression or any expression in the project management agreement that FirstService and the association were intending to indemnify third parties. The bank has argued, that FirstService has waived this point by not cross-appealing from the district court's finding or conclusion that the plaintiffs were in direct beneficiaries of FirstService's duties with respect to maintenance and management of the development. And it's true, we did not cross-appeal that, but we do not ask this court to overturn that. But that's a separate conclusion from the scope of the indemnity provision. And we are asking this court to affirm the district court's conclusion with respect to the scope of the indemnity provision. That takes up most of my time. Unless the court has any questions of me, I'll stand on my briefs as to other issues.
I do, and it'll probably display my ignorance about some of the details of this rather multifaceted case. But the indemnity provision you're talking about is between FirstService and the association, right?
Correct.
On its face. And if I recall correctly, was it a mutual indemnity agreement?
There were cross indemnity provisions, yes.
Okay. The other question I have is, FirstService is not contesting its liability for the $18,000 judgment. Am I correct about that?
You are correct about that.
Okay. Mr. Franklin, we see you.
Good.
Okay, that's all I have. Thank you.
Very good. Thank you, counsel. Mr. Halloran, we'll hear from you now. You have
Thank
5
you.
minutes.
Thank you, Your Honor. May it please the court. Parkway Plaza Retail Office Owners Association asks this court to affirm the memorandum opinion not providing indemnification under the statutes and the corporate documents and proceed accordingly. They want the association to indemnify the developer for actions of the developer's employees. And what we want to address in this argument today is just simply the statutory indemnity provisions of Kansas law. I apologize in my brief for any reference to later versions of Kansas Statute 176305, which had amended and removed language of employers or agents of the corporation. The correct statute would involve indemnification for officers, directors, employees, or agents of the corporation. It doesn't matter. It still does not provide NASB with the relief that it needs. Before, in the past, there was no right of indemnification for corporate entities. Delaware became one of the first states, and they provided indemnification, both permissive and mandatory. And Kansas has pretty much adopted the Delaware provisions, and we have a mandatory part, which is 176305 subparagraph C, and a permissive part, which is 176305 A and B. A is for third-party claims, B is for derivative actions, which are not involved here. The mandatory provision may create a right of automatic indemnity in certain circumstances, while the permissive provisions of the statute give the corporation the right to create indemnification if they so choose. Citing Wittig versus Westar Energy, which is the only Kansas case on indemnification, the purpose of corporate indemnification is to encourage corporate service by capable individuals protecting their personal financial resources because of the corporate service. NASB does not fall within that purpose, if you will, and that has been adopted in both Kansas and other states. The fundamental rules are the intent of the legislature governs, and that it's the courts give intention to the legislative view as expressed, rather than determine what the law should be or should not be. At the same time, courts are to avoid an absurd result. In this case, 6305C calls for mandatory indemnification of officers, directors, employees, or agents of the corporation that are successful on the merits. Here we have NASB as the developer who has the right to control the corporation, but they don't act for the corporation. They're actually there to sell their own lots as developer to minimize their loss on the loan as well as an owner. They appointed their own employees, Chris Vick and Donna Williams, to act for NASB, and then appointed them as an officer and a director. And we acknowledge that suits directly against Vick and Williams might actually lead to mandatory indemnification, but they weren't sued. NASB was. And NASB does not fall within the statute, and plaintiff provides no cases supporting their interpretation. One case that they do cite, Facina, which as a means of expanding the term of agent, involved a case against a corporate attorney who was seeking advancement for following an indictment in a lawsuit. And the court in Delaware basically said that the entity could only receive indemnification for the attorney acting as an arm of the corporation, an actual act. But it refused to give advancement for allegations when he was acting on behalf of himself. More importantly, Facina cited a Utah case, Western Fiberglass versus Morton, McConkel, and Bushnell, which was a legal malpractice action against a law firm for failure to protect security interests. The law firm claimed it was an agent of the corporation and therefore entitled to indemnification. The court rejected it, limiting it to those personnel exercising management discretion with authority to bind the corporation. What we have here is an outside entity that appointed these two individuals that's now wanting relief for it when it's outside the statutory language. Again, the purpose is to encourage corporate service by capable individuals. As far as permissible indemnification, there is no right to it under the statute. All the statute does is say you can offer it. And in this case, the only document that provides for any indemnification is in Article 8 of the bylaws, Exhibit 310, which basically says the association may agree to terms and conditions. I'm sorry, that's wrong. The association shall indemnify and advance expenses to each person who was or is an officer or director of the association or a member of a committee to the full extent. If you read the language, NASB does not fall within either the statutory mandatory right or the permissive right in Article 8, Article 15.4 of the bylaws. I think my time's up. Do you have any questions?
Panel, any questions for Mr. Halloran?
No.
I see none.
Sorry, I
Thank you,
rushed through
Mr.
that.
Halloran. All right, Mr. Franklin, you may have your 10 minutes of rebuttal.
Thank you, Your Honor.
And before you get going, I have a question for
Oh,
you
I'm
to
sorry.
follow up on Mr. Halloran's argument. When did the bank first raise the claim for statutory indemnification in this case?
I can't tell you that there's so many pleadings here, Your Honor. It would have been in an answer or responsive pleading when the association intervened. The association intervened in this case in mid-2015. And at that time, a responsive pleading would have been filed. And I believe that's the point at which the request for indemnification was asserted.
Well, was the request for statutory indemnification raised then, or was it raised for the first time in a motion to alter or amend the judgment that the district court entered? The end of the latter part of the case in the district court. Or do you know at this point? I don't want you to guess. You don't know, that's fine.
I can't tell you for sure when a specific reference to the mandatory provision of this statute was first stated. I'm fairly certain that it was in the pretrial order.
Okay. And I mean, obviously all that's in the record and we can track that down, and we have helpers to help us track that down. So, okay, I'm sorry, go ahead.
Right. To return to the part of the dispute with the plaintiff here, I want to point out that the Kansas appellate courts, in interpreting declarations, have been clear that isolated, as counsel for Payne Consortium pointed out, isolated provisions of a contract are not to be read to the exclusion of other relevant provisions. And here, the provision in Section 22 on delinquent assessments specifically recites that the association is to be the party that collects dues. And under the third-party contract beneficiary analysis, the court is to look at the very specific provision that allows enforcement of a contract with respect to delinquent assessments. Here, that provision is in section 22. It's very specific in saying that the association can engage the services of an attorney to collect any assessments that are delinquent. That did not happen here. The association was a party and it never sued NASB for dues. In fact, by mid-2015, the trial court had entered an order for a receiver that took all the powers with respect to collection and put them in the receiver. And the receiver then followed up, and by August of 2015, in a report of the receiver in volume 17, page 270 of the record, the receiver submitted his findings as to what was necessary to collect dues from owners. And at that time, there were approximately $300,000 of dues owed, and the receiver undertook to handle those collections, including bringing a lawsuit separately against Payne Consortium for $121,000 of dues that were owed. So the idea that Payne Consortium could come in under the more generalized enforcement provision that appears in section 24, that's designed to make sure that an owner can sue and stop somebody from starting a cannabis store or something else that violates the provisions, that's just not a full reading of the declaration. Section 22 has very specific provisions about who's going to enforce assessments. And there's a good reason for that. From 2010 forward, Payne Consortium never, ever paid dues until after the receiver sued it in this case. It made no efforts to undertake to pay that $121,000 worth of dues that were owed per the report of the receiver in August of 2015. So what you have is Payne Consortium claiming that it had $18,000 more it could have realized in the sale of Lot 11 if only NASB had paid its dues that were paid up by April of 2015. That lot sale happened in January of 2016, and it happened after, remember those dues that Payne Consortium owed, it didn't pay until the month before that lot sale occurred. Here, the trial court did not undertake to figure out who owed what dues when, because it found it apparently more difficult than it wanted to undertake to sort through the bookkeeping records and to figure out what dues exactly NASB owed when and what dues Payne Consortium owed when. And I want to point out that in addition, that report of the receiver that was filed August 13, 2015 shows $300,000 of other owner dues. None of those were NASB. So the idea that the judge could rely on an expert opinion in 2016 that one lot would have sold for more if dues would have been paid simply does not take into account the $300,000 of unpaid dues that spread over a period back to 2012, and it doesn't factor those in. With respect to the FirstService arguments about not wanting to have section 10 of the property management agreement read to provide for hold harmless to an owner as a third-party beneficiary, the NASB response is that there were officers and directors, and the record's undisputed here, that repeatedly contacted FirstService and asked it to do its job. The central dispute here seems to be that dues were not getting paid. That was FirstService's job. It didn't do that. The testimony was admitted that it didn't do that in 2012 and 2013. It breached a contract, meaning FirstService, that it owed duties to the association to get that job done. Calculating, billing correctly, keeping accurate financial records of dues owed. That was FirstService's job. That was not the job of officer directors. And finally, with respect to the association, the mandatory provision in the statute with respect to the payment provides that if actions are disposed of favorably to NASB, they should be paid for those dues. The language of the statute that applies here should be read to encompass NASB. I'd like to close with just one reference here to section 12 of the declaration. That's the provision that says there's to be no personal liability on the part of NASB. A fair reading of the language in that provision of the declaration is that there should be no personal liability for a developer or any member of the board here. The trial court's reasoning as to why it would not apply section 12 simply is not persuasive or a fair reading of the English language. And I would point out that section 12 and the no liability provision is entirely consistent with the immunity provision in 60-3601, which provides immunity for liability for volunteers. And if section 12 didn't apply and a tort claim would have been allowed to proceed here, that immunity provision in 60-3601 would have applied to NASB. For that reason, NASB asserts that the no liability provision of section 12 and the immunity provision of 60-3601, if section 12 had not applied, would bar any claim for personal liability here to Payne Consortium. And NASB requests that the court reverse the judgment against it for $18,000 and provide that FirstService owes the protection due it under section 10 of the property management agreement and or provide for the statutory indemnity that is owed by the association to NASB.
Thank you, Mr. Franklin. Your time has expired. Counsel, thank you very much for your arguments today. It's a complicated case, and we'll do our best to figure it out and issue a written opinion as soon as we're able. Thank you all, counsel.
Thank you.
Thank you, Your Honor.
Are we allowed to leave, Judge?
Yes.
You're encouraged to leave.
Thank you.